Okay, we're gonna take the cases in the order that I called them. So we'll start with the Long v. Long case. Counsel, we're here on a motion to enter. Go ahead.
Yes, Your Honor. This case was filed in August of 2022. We then mediated it with Charlie Bowes, and subsequently, Mr. Friday and I were able to settle it in November of 23, just with an informal settlement conference. As part of that agreement, we agreed that Mr. Bowes would be the arbitrator. We then had some arbitration disputes, and if you'll see in the box, our first exhibit is the arbitration award that admittedly we just received yesterday. However, it's fairly simplistic. It is simply an issue on the Children's Bill of Rights, whether or not chewing tobacco was included as something in the Children's Bill of Rights, and then also an issue on the CTA in terms of some language that Mr. Friday wanted. Mr. Bowes sent back the arbitration award. And we have included that. So I apologize for not being in a suit. I did not think I would have to be in court today because I was under the impression we had the arbitration award. We've set this hearing. So it was just a matter of you signing it. I found out this morning, about 15 minutes ago, that that was not the case, that Ms. Long planned on not signing it. I think Mr. Friday's argument is going to be that she's on a plane, that she was in Milan, and that she needs more time to review it because she wasn't satisfied with the result of the arbitration award. And so he would like you to say that she has to sign by a date certain, and then at some point in the future, she would sign. And if she didn't, I would have to come back and do this all over again. The two options that one of them, which I have discussed with him, is I said, well, the decree is very easy. It's just about the Children's Bill of Rights and whether chewing tobacco is included. Can that be signed today? And if she doesn't feel comfortable with the edit that was made by Mr. Bowes as it relates to the arbitration award, could she sign that later after discussion with you? That is one option. The other option would be she needs to sign by close of business today. Otherwise, you as the judge will sign it in the morning. I just don't want to go through this exercise again because I fully expect her to continue to not sign given the tenor of this case and how it has proceeded. Mr. Friday will say, absolutely, I'm going to get her to sign, but I know that he knows that there's a possibility that she will continue to not sign the decree in question.
Okay. Mr. Friday, you want to weigh in?
Yes, Your Honor. Good morning, Judge. How are you?
Good, thank you.
Yeah, I mean, truly, this isn't a contested hearing to that extent. The way that I understand it should proceed, though, both for, honestly, this is as much for them as for our side, is there were disputes regarding the drafting of the decree as well as some ancillary documents. We submitted that to Mr. Bowes for arbitration. Mr. Bowes has issued his arbitration award. We got it yesterday. And so what I think the next step is, and this setting was by agreement. In other words, both lawyers understand the need for the courts to tell these parties to do things. So I'm not opposed to that. What I believe, though, needs to happen is that you need to approve the arbitration award, adopt it as the order of the court, as the final order of the divorce decree, as decided by Mr. Bowes in his arbitration award, and then order the parties to execute that document. The reason I think that's important is that it is referenced as an agreed final decree of divorce. And I don't know if you have seen it or if you want me to pull it up. If I may, can I share screen real quick?
Yes, you may.
And so on page 2, can everybody see that?
I can.
On page 2 of the decree, there's this section here about agreement of the parties, and it talks about how by their signatures below they are agreeing to, and there are specific reasons why it's important for it to be an agreement, not just an order of the court. And so you signing this decree without my client's signature on it, yes, we'll make it an order of the court, but it won't be an agreement. And so honestly, I'm okay with that if you want to sign it, and if it's Ms. Londegren's position that her client's interests are best suited for you to sign it without my client's signature, then I'm fine with that. But again, I just think the proper way to do it is approve the arbitration award, order the parties to sign it by a date and time certain, and then their failure to do that would be a motion for enforcement and theoretically contempt for them not signing it when you do. And so then that's what I'll tell my client is that you don't have an option not to sign this. You need to sign it. But I would like the opportunity to explain to her what it is that Mr. Bowes did and why he did what he did, or at least my understanding of that, because she does have some questions. And as referenced by Ms. Londgren, she is currently in the air flying back on a 10-hour flight, and I won't have the opportunity to talk to her today.
Okay. All right.
My response to that would say that I don't want to have to do an enforcement.
I guess we can pull the document down, Mr. Friday. And then back to Ms. Londgren. So I guess if you could enlighten me as to whether you think approval of the arbitration award with a date for the parties to sign is appropriate, or is there something a little bit different that you're asking for? Just want to try and see if we can all get on the same page here.
Yeah, so the two options I had was sign the decree today. Mr. Friday says that I'm then leaving remedies on the table in terms of the fact that she didn't sign it. And I have said, well, I just want an order. It's very common for people to sign an MSA and then later be upset about it. And even though it was an agreement, because there was an MSA, they refused to sign the divorce decree. What I don't want is to have a date certain. Let's say by Friday she has to sign and then she doesn't do it. And I have to go do the rigmarole again, do a motion to enforce, and then potentially get her served with it when this divorce has been ongoing for 2 years. There's issues involving the children. I think for purposes of the children and the family as a whole, if we're being child-centric, it is better for them to have closed this chapter gently and to move on and not invite more litigation and another 30 to 60 days of something. I would much rather, even given what Mr. Friday has said, have it signed today. And yes, I do think you need to approve the arbitration award.
Okay. All right. And let me just look back. Okay, sorry, I'm just looking through box. So I see the agreed final decree. Does it have language in it that approves the arbitration award, or is that a separate order that we need to have put together?
The honest truth is I have not been in this situation. Usually when somebody issues arbitration award, everybody signs. So Mr. Friday, I think we're in agreement that there's not an arbitration approval in the decree. That would have to be a separate document.
Yes. And again, just because I'm trying to be honest and not make this more difficult, I have signed the decree as approved as the form because, again, I understand what Mr. Bose has said, and he has said this is the form, and so I've signed it. Ms. Longren's associate has signed it. I believe Mr. Long has signed it. If they want you to sign that decree, I'm not going to stand in the way of you signing that decree. I think it would be better to give my client the opportunity to sign it as well, but I'm okay with that. If they want to forego those additional remedy options of it not being an agreed decree, then I don't have an issue with that.
Okay, and Mr. Friday, your client's going to be landing sometime today.
Yes, my understanding is it's a 10-hour flight, and I think she took off about 30 minutes ago.
All right.
So that was the other option, is like give her, like, by close of business today, you have it to sign. And then if she still hasn't signed it by close of business, then you would just sign it so that we don't have to go through the rigmarole.
Okay.
And if you were going to do that, I'd ask for more than, I guess, 12 hours though, because if she lands at 7 p.m. here, I'm no offense to her, but I'm not going to spend my evening talking to her about things. I'll talk to her tomorrow about it, but I won't do it tonight.
Okay. Here's what I'm going to do for this. I'm going to give her until Friday, close of business, Mr. Friday, to get the decree signed, and back to the court. Okay. I will approve the arbitration award. And if you want to submit an order to that effect, please go ahead and put something together, and it can be emailed to Ms. Seeger for my signature.
If you don't receive it by close of business on Friday, will you
I'll
sign it?
Yes,
Okay.
I will. I will enter the decree on Friday. If I don't have the signature by 5 o'clock, Mr. Friday, I'm going to go ahead and get it signed.
Excellent. I think that's a good way to do it.
All right. I appreciate your time. Y'all are both excused from the virtual courtroom.
All right.
Thank you, Your Honor.
So much. Have a
Take
good
care.
day.
I'm just going to take
Thanks.
you to Bradbury
Bye.
versus Mook. And I understand y'all are both representing yourselves here today. Y'all can go ahead and unmute and let me know where we are on this.
Yeah, so from at least my perspective, and I think Sam and I are on the same page, this is more of just a formality because we are in agreement on the kind of what we would like to have happen. I originally filed for sole conservatorship in 2022. And then, we agreed between the two of us. We came up with a mediated document between the two of us. We submitted to, the family law review, case review. And then we've been working with them kind of back and forth to get the documents signed through the DocuSign, et cetera, et cetera. And then schedule the hearing because we know that even though it's a mutually agreed upon case and we both signed off on it, because of the nature of the case, it requires a hearing.
Okay, so do you have an agreed order then to present to the court for entry, or?
Yeah, so we had given that to the the woman who was working with us on the case review. And it was submitted through the DocuSign. I mean, I can look back and see if we can find a copy of it. I'm guessing by your question, you don't have it.
I do not have anything on this case unless you've sent it in or
Okay.
uploaded it to Box.
Okay. So I'm not sure where I would find the one that we signed through DocuSign. Modification order and exhibits. Let me see. Oh my gosh, this is not the time, Kat.
It looks like the law library has a folder where they submit documents, and it looks like there is a folder with a modification order, so I'm gonna,
Okay, I don't know where that is.
no, I have it. I have access. It's under the M drive. I can pull it
Okay.
up for you to, I just want to let you know that
Okay.
they submit, if y'all have gone through them, they submit it. I just didn't know that until you just said that, so I will see what I can pull it up real quick.
Oh, great. Thank you.
Take me
Thanks,
a few
Pam.
seconds to forward it to the judge.
Sure, no worries. All right, Ms. Bradbury, while we're waiting for that document to come through, why don't you go ahead and tell me, so what are the agreements concerning conservatorship and the child?
Yeah, so we agreed to award me sole conservatorship. We also have a modified possession schedule that we included, where Sam will have possession alternate Fridays from the time school ends until around 8:30 p.m. and then every Tuesday evening from 5:30 p.m. until 10 p.m. We share all holidays except for Mother's Day. And we have a possession time of 4 to 8:30 on Father's Day. And basically, all of the transitions happen at the child's residence, which is my house. And that's basically, I think, what we agreed. Did I miss anything there, Sam?
Oh, you're on mute, Mr. Mook. Sorry about that. If you could just hit unmute.
All right. First off, I want to apologize for not wearing a suit. I didn't know. No, I'm just teasing. Yeah, no, all that sounds perfect. Like everything, I would have chimed in earlier, but I've been muted. But yeah.
Okay. Well, no worries. Only attorneys are supposed to wear suits to court, so
Okay. Okay.
you're okay on that.
I
Okay.
wasn't sure on the protocol.
No, let me see. Okay, I do have the proposed order here. So let me open it up and take a look and see if I have any questions for you. Okay, so I do see the signatures of both parties here. Okay, so if I'm looking at page 3, there are a number of boxes that aren't checked.
Page 3.
You know, the Mother's Day, Father's Day, there's boxes to check based on the time, and those are not indicated one way or the other.
Right, yeah, so we just did we covered all of the holidays.
But it
Including
doesn't give
Mother's Day and
time,
Father's
so
Day.
it's vague.
Yeah, on page, in the supplement under the modified possession and access order. So we didn't duplicate those, but I mean, we can just pull that information up to the other document if we need to.
Okay, I don't have something called modified possession order. Is that something different?
So the PDF that I'm looking at, which I don't know if it's the same one that you have, is a 14-page PDF that's a merged document. So on page 5 of the merged document, no, 6 of the merged document. Nope, lies, sorry. 8 of the merged document. It has the all holidays except Mother's Day and birthdays are shared. Father's Day possession is 4 o'clock p.m. until 8:30 p.m.
Okay, so I have no idea exactly what you're referring to.
Does the PDF that you're looking at have 14 pages in it?
It doesn't have pages at all. I mean, not that I can check anyway. I don't know why it's not showing me pages, but there are page numbers at the bottom, but there's
Yeah,
1 through
so
6 and then maybe 1 through 4. So it
yes.
is multiple documents, but I can't, I'm not on the same page as you, clearly.
Yeah, so in this, so it does have 2 documents. There's 1 through 6 and then 1 through 4. And it's page 2 of the 1 through 4. So it's the second page 2.
Okay. And okay, still there are boxes to check and you have not selected any of these options.
Okay, so we need to bring the information that's on that second page up to the first document as well.
Well, I don't see even boxes aren't checked on the second page. So Christmas holidays and even numbered years, is that the page you're on?
Yes, yeah, and so it says they're all shared up above it, so that's not enough detail.
I don't see where it says they're all shared.
Okay, may I share my screen?
Yes. Oh, that is not what I have,
Oh,
period. That's not on the page 204 that I'm looking at.
okay. Okay.
Oh wait, let me see. Hold on, I scrolled up. Okay. Okay, I guess that works. The problem is it kind of the way it's put together, there's conflicting things in this order.
Mm,
And we don't like to have that.
okay.
And the law library reviewed this?
Yeah, a few times.
I think the problem is you're trying to use a standard form when you have come to an agreement that is not standard.
Yes.
And
we tried originally submitting a non-standard form that we had created with the help of Sam's sister, who is a family law attorney in South Carolina. But the law library said we needed to redo it in this format and submit it this way. Which I can find that form. I should be able to. I have it. So this is what we had originally submitted to the law library. But then they said we needed to basically redo it through the standard form.
okay. Well,
and they also said that the language, basically where we had left it open to be flexible in terms of the visitation schedule, needed to be refined to like what the specific visitation schedule would be. Which originally we had wanted to leave it more flexible, because based off of changing circumstances, to leave room for that change instead of having it like set in stone. But based off of the advice of the law library, we just submitted what his current visitation schedule with them is.
okay. So I understand why. So a flexible schedule isn't going to be enforceable. You have to have a schedule that sets out days and times. Orders have to be clear in order to be enforced. So that's why they told you whatever flexible version you had was not going to work.
Right.
However, what you've given to me is not clear. In other words, part of the order it says this, another part of the order says something else. It would not be enforceable based on the document that is in front of me. So
Okay.
I guess I need you to explain the schedule that you have agreed upon better, but I mean, I can't sign the order that you put in front of me. It's not enforceable.
Mhm. Okay. So I guess, should we go back to the law library? Or I'm not sure what the best way to proceed in terms of making it enforceable is, because obviously this is not my area of expertise.
So the law library has some limitations. I mean, they don't represent you nor Mr. Mook. And they do help people put together standard forms that can be entered by the court. But the problem is you're trying to do something non-standard on a standard form. And
Mhm.
I'm just not sure that that is going to work. But so the order that you presented says something in one place and then says something else in a different place. That's
Okay.
not enforceable and the court can't enter that. So I think it probably would be helpful if you go back to the law library and ask them for some further assistance. I don't know, but basically,
Do you mind clarifying for me where the
Inaccurate or inconsistency.
yeah, just where the
sure. Why don't you pull that page?
inconsistency is?
Why don't you pull that page back up that you had about the holiday visitation?
Yeah. Uh-huh. Hold on. Yeah, just so I can know where the imprecision is and where the inconsistency is, because I think that would really help me. Thank you.
Sure. Okay, so in the top of this page, you have an order, parent B has possession every Tuesday from 5:30 to 10, alternate Fridays 3 till 8:30, and then all holidays except Mother's Day and birthdays are shared.
Hmm.
Well, number one, I don't know what shared means
Right.
for holidays, so that I can't sign that. If you scroll down, the form has Christmas holidays for even numbered years, or go to parent B and it starts
Right.
either at 6 or when the school is dismissed. You got to check one of those boxes. And then Christmas and odd numbered years are for the other parent. I have no idea what shared means.
Well,
Right.
Nobody
Yeah.
can enforce, you would need to define share.
Mhm.
I mean, basically, this proposed order creates more problems than it solves, basically.
Mhm. Yeah.
Shared is not defined in the agreement itself.
So for example, we would need to say, like, let's
Parent
itemize
A,
them out. So like Christmas morning, parent B comes to resident of parent A at 6 a.m. for present opening, 6 a.m. to 8 a.m. for present opening and breakfast.
if that's the agreement, it
Right. I
would
mean, that's
need
what
to
we've
be.
been doing, right? That's about what we've been doing, right, Sam?
Yeah. Yeah. That's what I was gonna say. Like it's and Thanksgiving doesn't really count.
Yeah.
I mean,
Yeah, screw Thanksgiving.
like I don't know, but like if we both agree on shared, like what that means to us, and we work together really well. So I don't.
Yeah.
Yeah, I don't see a box for us to check.
Right. So I guess we
How-
just need to spell out how we're sharing each of the holidays in that text.
Okay, Ms. Bradbury, let me ask you, do y'all have a mediated settlement agreement or a written document that has the agreements that you've reached that isn't what I'm looking at now?
No, the only other document that exists is just the final decree of divorce from 2019.
Okay, because so one alternative would be, well, I would definitely start with the law library, but you can put together all of the agreements that you have in writing and submit those either to the court for entry or just file the agreements in the court's file, and that could govern. But talk to the law library.
Okay.
There's always, everything doesn't have to be in the order that you can always agree while you're getting along. It's just difficult with holidays and things do sometimes have conflicts arise, but it seems like y'all are cooperating. But as far as court orders and things that a judge signs, it needs to have a certain level of specificity, and shared doesn't have a meaning in the proposed document. So basically the proposed document is just unworkable as written. So let's go back to the law library, explain the situation, see if they can give you some guidance as to the best course going forward. But it just, in order for a judge to sign this, it needs to be more specific.
Okay, yeah.
And we don't need to, if you get the assistance you need from the law library and have something ready for the court to review, we don't have to set another hearing. You could send it to our submission. We might be able to handle it without a hearing if everything looks good and is ordered. You could send that to Ms. Seeger via email or to our submission email inbox.
Okay. So I'm just going to clarify. So we're going to take this. I'm going to reach back out to the law library. We're going to be very specific about the definition of shared. I'm just going to go through each of the holidays. We're going to name what we do on each of the holidays. And then we'll re-sign that in the DocuSign, and we can email that to Ms. Seeger and the court email and see if we don't need another hearing.
Yes, I think that would be best. I mean, a big part of the problem for the court is that the order isn't specific enough to be enforceable, and you state what your plans are doing, but shared, I mean, no one knows what that is other than you. If it's not written down, then it can't be enforced. And the other problem is, it says all holidays except Mother's Day and birthdays are shared. And then it goes on to say Christmas and even numbered years, Christmas and odd numbers. It conflicts with itself the way it's drafted. So it needs some cleaning up. And before it can be entered. Oh, does that make sense?
Yeah, I think I have a clear understanding of the level of specificity that's required, and I don't think that should be hard for us to do because we already know what we do on all of these holidays. We can just list it on out. Do you feel the same way, Sam?
Ms. Bradbury, you're cutting out a little bit.
Oh, sorry. I said, I think I have a clear understanding of the level of specificity that's required, and I don't think it should be difficult to just list off what we already do on all the holidays, and then just go from there.
Yes. Okay.
Yes.
All right. It sounds like y'all have a plan, and we will wait to hear from you or the law library before we move forward.
Okay, thank you so much for the clarity.
Thank you all.
Okay, y'all are excused from the virtual courtroom.
Awesome, thank you.
003011.
Thank you for your
If we could start with everyone just giving their announcements.
Your Honor, I'm Gerald Smith. I am replacing Mr. Ronnie Jones, initially the plaintiff, representing Mr. Leo Graves and Sherelle Slade.
Dennis Eichelbaum on behalf of the Carthage Independent School District.
Mason Kura on behalf of Texas Education Agency.
James Parker, I am the appointed attorney ad litem.
Okay, thank you, everyone. Mr. Parker, the court wishes to thank you for the work that you have done on this matter. And I will start out by saying I think everyone in the virtual courtroom is aware, but on May 31st of this year, the Third Court of Appeals issued an order and a memorandum opinion in which it became known to this court at that time that Mr. Jones had unfortunately passed away. The appeal of this matter to the third court had not been pursued, and they abated the appeal, remanded it back to this court so that I would notice a hearing and find out whether the appellants desired to prosecute the appeal, and if so, who was going to step in to replace Mr. Jones. So I guess, Mr. Smith, let's start off with you. I did see your representation letter. Are you just representing Mr. Graves? What about Ms. Slade?
It will be Ms. Slade as well, and I'll talk to my office about correcting that. We're just so new on the case, and we're trying to collect information as we go. But it should have been a representation for both Mr. Graves as well as Ms. Slade.
Okay.
And so I'll get that corrected, John.
Okay.
So I am new to the case. I've tried to go through the court's papers. I've tried to, get more than just a neighborhood story of facts. I want to know what the actual facts are, what was said in the courtroom. And I do have a copy of the transcripts. I've just not had an opportunity to review the file to make a decision or look at the law to see what the proper course would be. And I'd like to advise both Mr. Graves and Ms. Slade as I proceed. So I would ask the court, I've already spoken with Mr. Parker, the attorney at law. I spoke with Mr. Alkenbaum. I think I pronounced that right. And I spoke to the USAG, Mr. Curry. And neither are opposed to me asking for an extension of time in order to get smart on the case so that I can properly respond. So, Your Honor, I would be asking for about 30 days to prepare. Either let the court know if we're going to actually prosecute continue to prosecute this appeal, or go ahead and just let it go one way or the other. But I would like to have a chance to investigate and determine which direction to go.
Okay. I guess let me hear from counsel for the appellees then.
On behalf of the school district, we don't have any objection to a reasonable extension for him to be able to review the case, talk to us, or whatever he needs in order to be able to best serve his clients.
And TEA has the same position as the school district. We're not opposed to extension.
Okay. All right, Mr. Smith, in looking at the Third Court of Appeals' order to this court, I was directed to, within 30 days of this hearing, to file a supplemental clerk's record. And so that means I don't need to file the supplemental record today or tomorrow, but the court has 30 days in which to accomplish that. So what I would plan to do is get that done by that 30th day. Of course, as far as whether you need any further extension, I believe you would need to take that matter up with the Third Court of Appeals, because my scope is limited to just conducting this fact-finding mission. I will issue the requested findings about appellant's desire to go ahead and pursue the appeal. And but you may, if you need any further time, once the matter is sent back to the third court, you'll need to take it up with them.
Yes, ma'am. I understand. And I'm certainly thankful.
Okay. I appreciate it. Well, I appreciate you all appearing virtually here today. Is there anything else that we need to cover or discuss?
Yes, Your Honor. I just wanted some instructions from the court as to whether the court needed any additional assistance from me to continue serving as ad litem.
No, now that counsel has been identified who's going to substitute not just for one plaintiff, but for both based on Mr. Smith's representation, I believe that you have fulfilled the court's request as far as the order appointing you. So
Okay.
I think that that has been completed, and I think the court's order indicated that that your services would be taxed as court costs. So I believe that your duties have been fulfilled and you are discharged, Mr.
Okay, all right. Well, thank you, Your Honor.
Okay, great. Anything else before I excuse you all from the virtual courtroom?
Not from the appellant.
Okay. And I see no's from the other side. All right. Counsel, sorry to be meeting under these circumstances and to hear about Mr. Jones's untimely passing. And I do appreciate everyone's attendance here, and we'll go.